You must understand the historical context in which this happened. This has not happened in an isolated fashion. The Parliament of India, the Constituent Assembly in India, framed a constitution which included a provision for a Constituent Assembly of Jammu and Kashmir. Surely that was not an isolated act. This happened in consultation and in agreement with the then Maharaja.
And the J&K constitution contemplates that this legislative assembly will have no role in regard to the amendment of the provisions of the constitution relating to Article 370.
Otherwise, they would not put that phrase.
But then how would that, what sort of a
next question is, supposing there was no constituent. That's the next question.
How do we, then what constitutional mechanism would be envisaged then?
If there were no constituent assembly and your lordships were sitting in 5, I would have answered that question, but luckily we have a constituent assembly. But I can't answer a hypothetical question as to what would happen.
How would you then put into place the constitutional machinery? Because there has to be machinery. It can't be that, because there is no constituent assembly, because there is no constituent assembly, you cannot at all deliberate on a proposal for abrogation or modification of Article 370.
Your lordship is putting to me, supposing the Maharaja refused to have a constituent assembly.
No, take 2019.
I'm sorry?
Take 2019.
Yes.
When the Constituent Assembly has been convened, the Constituent Assembly has drafted the Constitution.
Yes.
Therefore, its role has come to an end. There is no Constituent Assembly.
Correct.
2019. The government the president wishes to modify Article 370.
Yes.
Now, we've seen the process which they followed.
Yes.
What, according to you, would have been the constitutional process to...
No constitutional process, because the Constitution of Jammu and Kashmir said, in terms in 147, that no such bill can be introduced in the legislature.
Oh, by them?
By them.
I'm talking about, no, by them, where the constitution as it applies to the state of Jammu and Kashmir, which is part of the law applicable in Jammu.
So, according to you, no constitutional procedure can be initiated for abrogation of Article 370 at all.
I've been saying it's permanent. Why do you, I've been
The argument is that after 1957,
yes,
the president ceased to have any power under Article. That
was temporary between 1951 and 1957. Where do you get that power from? You see, the point is, Malaj, at that time it was temporary because there was nothing in place.
After 1957, sub-article 3 has become OTOs now.
Yes, no, Malaj. It can happen as a political decision. The Jammu and Kashmir government and the legislature of the state unanimously did what, and they merged. That's another issue altogether.
So, Mr. Sibal, according to you, neither the assembly can do it,
yes,
nor the parliament can do it.
Yes.
What you are saying is, while other provisions of the constitution may be capable of amendment through a process envisaged for amendment,
yes,
other than, of course, if it is hit by basic structure,
correct,
this is one provision which can never be amended.
Well, and let it put it differently. But let me put it, under what power will this take place? Let's assume they can do it. If my lords put the question to me, under which provision of the constitution can they do it?
Having a permanency, the whole concept is that constitution is also a live document. At some stage, can we say there is no mechanism whatsoever for ever changing it, even if everybody wants to change it, and it doesn't affect the basic structure? Then to say that if suppose all of Kashmir wants it, hypothetically,
then a political act can be. But there can be a political act.
And those negotiations.
Clause 1 is the answer to this. 370 clause 1, bit by bit, modifications, exceptions, applications have come. Now, and one important thing your lordship may note is it's completely irreversible. Because it's completely irreversible, all those parts which have now been brought in, they cannot now reverse. So part 3, for example, have come in with
Can Parliament not have amended the constitution exercising the 368 power to abrogate 370?
No.
Which means, therefore, that there is a provision of the constitution, apropos what fell from Brother Justice Call, that according to your submission, there is a provision of the constitution which lies even beyond the amending power of Parliament.
That's right.
Your lordship may note.
So we are creating then a new category apart from basic structure.
No, not
that 370 belongs to that.
It is inherent and it's integrated into 370 itself. It's not a new category. It's a category that exists.
370 clause 3 only provides that if you want to abrogate, there is a mechanism for abrogation, which is why it's temporary. Now, if 370 clause 3 goes and is not brought into service, 370 clause 1 can now be used continuing with the with the government of Kashmir giving its consent, and the entirety of the constitution can be made applicable to Kashmir still under 370 clause 1. It can still be done. So the answer is not that it can't be done.
I'm sorry.
Let's assume
Is it-
what your argument on clause 3,
Is
which has
allowed.
been argued that clause 3 is today etched in stone, is now, it cannot be.
Not done.
Want to put
Yes.
is that 371, according to 370 subclause 1 itself envisages bringing in different provisions.
Correct.
Tomorrow, through that process, it is said that each and every provision of the Constitution applies to the state of Jammu.
Yes.
Then what remains of 370?
Nothing.
Then the only,
Then to say that you can,
It can
in
be
a sense, make it, make completely 370 infructuous, yet it is sacrosanct where it can never be removed.
Let me just explain, Manoj. Clauses 1 and 2 and 3 have to be read together. 2 is transitory. 3 provided for abrogation to be temporary. So if you have a constituent assembly and they are giving their recommendation, then the abrogation was immediately possible. It's a shortcut and 370 comes to an end.
no,
The long way around is through 370 clause 1 with applying provision of part
So I'm
1.
saying therefore said that
Yes.
371, according to you,
Yes,
can mean, orders have been issued from time to time.
yes.
That it can say that each and every provision of the Constitution.
It can, of course.
Correct. Once we come to that,
Yes.
I'm just thinking aloud. What remains in 370 after that? Which means
So
you are saying the shell of 370 should remain, but the substratum can
we are
be.
saying that assimilation needs to follow the correct procedure. The 370 clause 1 procedure is still available, was what we are arguing.
I don't know what
It's
he's arguing, but it's certainly not what I.
This is what we are saying.
Yes, Mr.
That,
Yes.
that may be his
The
interpretation.
expression.
I think, let Mr. Sibal come, because, otherwise that will, I think, Mr. Sankarnaran, what will happen is, we are following a certain line and a link and a syntax, so, I mean, I think, we might be broken up in the nuance of.
Because, respect Mr. Sibal, he knows the law. We also therefore didn't jump and answer the questions.
I don't think.
See, the nuances are so many as something Mr. Sibal is arguing, something which you propound to do so. Mr.
Yes, he
Dwivedi
can.
said, no, this is not what I'm saying something different. So we'll have to see where the call rests.
You can
I
say
understand. So
something
your
different. There's no
argument I've
issue at all.
understood at your own turn. He says that you can keep the shell, but the process is to 370 and
So
1.
there is another interpretation.
The problem is that if there's a constitutional process to do it, it can be done. If there is no constitutional process to do it, then it has to be a political act.
और आप हमसे जुड़े रहने के लिए सब्सक्राइब करें YouTube पर, फॉलो करें Twitter पर और लाइक करें Facebook पर। और ज्यादा जानकारी के लिए आपको टाइप करना होगा सिर्फ न्यूज़ नशा।